maybe I'm just sort of curious, Brian, in addition to what you want to share, being a lawyer and having times when you just aren't going to know, and the discomfort of not knowing outcomes, what somebody's going to do, what a client's going to say, how a person is going to respond, what a judge is going to rule, whatever that may be, what you think, where there's a mastery of working skillfully with not knowing.
I think you embrace it. There's nothing worse than pretending you know when you don't know. First, you said that you give off the vibe that you're bullshit. Second, the person who listens may actually know more than you know and know that you're bullshitting. And third, you just have this unease about it. And finally, everybody doesn't know something, right? You know, so there's nothing bad about not knowing. And I think lawyers absolutely, have this compulsion to fill up time by talking. I'm certainly no exception. And I also feel like they know everything. And there is nothing more disarming in court or in a negotiation to say, I don't know. That's a good point. I've got to think about that. I mean, I've used that technique and I've never lost, that I can remember anyway, lost ground because of it. It gives me time to regroup and think of something. And I think it's also true of other weaknesses, which I don't really think are weaknesses. If you're talking to a jury or a judge, I always thought you had to look like you're super in control and command and smooth and all that. And actually, jurors, if you think about it, are human beings who themselves are not perfect or in control and command. It's a pretty stressful situation. If you actually admit that, if you actually somehow connect to them and let them know that, so many of you are nervous here today, most of us don't talk like this in a public setting. It's perfectly fine. In fact, it's a big case for me. I have to tell you, I'm a little nervous, but I might not do it right or do it perfect.
Yeah.
That's disarming. And so I think you can embrace these things.
And connecting, right?
Yeah.
And connect is part of the disarming is also your forging a connection.
Right.
Can you tell the difference between doing that as like, oh yes, I'm beginning the trial, we're with the jury, that's the thing I'm going to say because I've said it before and it's disarming and it works, so I'm inclined to want to do it again, and doing it when you're actually feeling the genuineness of what you're saying. Can you speak to that as a device that somebody might say, oh, now I'm going to do this like I wrote down, I'm going to do it, and then really connecting to the truth of it and the impact of that on the jury or the person you're connecting with?
I mean, honestly, I do both. I'll do it because I think it's effective and I've done it before, just like you said. And I'll do it when I actually feel it. With a judge, for example, how do you distinguish blah, 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 blah? And I don't know. I guess I'm screwed, There is, I was an arbitrator in a case 2 weeks ago. And fabulous lawyers on both sides. And one of the lawyers wouldn't answer a question. And it was the question was fundamental in the case. What is the bank's fiduciary duty? How you describe it? And I was asking him, he wouldn't answer. And if he just would have answered the question, or if he just would have said, I know that's fundamental. I know that's important to you. I want to make sure that I say it exactly the way I want to say it. Can I get back to you on the next break? What do you do with that? You're not going to say, no, you can't. It's disarming, it's charming, it's real. It's real. So you go along with it.